Thank you. Thank you everyone for being here in one more course in AMP. I'm very glad to announce you that today we have the presence of Trust Rivera Law, representing with Eduardo Sanchez. Rivera Law offers integral legal services to ensure a streamlined and secure real estate transaction in Mexico. Their mission is to assist our clients in every stage of the real estate conveyance procedure and to offer all those services connected to the purchase process. They review all documentation on the property. They comment and negotiate terms of the purchase agreement, incorporate the bank trust necessary for purchase, and coordinate the closing on the property. Their skills, contacts, and knowledge allow them to offer our customers an expedite, economical, safe, and clear transaction. Trust Rivera Law can help us with the process of acquiring a property in Riviera Maya, while reducing time invested in legal procedures and other related matters. They will make the purchase of the property a seamless, cost and time-efficient process. This will allow us to enjoy the experience of buying a new home while not having to worry about risky, costly, and frustrating delays. Eduardo Sanchez is an attorney specializing in cross-border real estate transactions. He attended law school at the University of the Americas in Puebla, Mexico, where he obtained his law degree and a specialization in internal law. Eduardo joined first American Title Insurance Company as an First American, he was involved in numerous real estate transactions, both on the commercial and residential level, as well as managing client relations and emerging market development. Eduardo was founding partner of Mexico Title in Puerto Vallarta, a law firm focusing on consultation for foreign national purchasing property in Mexico. He has been involved on a partnership and management level with several real estate developments in the Riviera Maya area and has extensive knowledge on the property conveyance procedure in Mexico. Please welcome Eduardo Sanchez Garcia Real. Wait a moment, please, Eduardo. I think your mic is closed. All right. Who is the host?
Yeah, your microphone is off.
En oficinas me pueden ayudar con el micrófono, por favor. Creo que no estoy como host.
Ya le enviamos solicitud para activarlo, pero no.
Muchas gracias. Eduardo. Perfecto, gracias. De acuerdo. Muy bien, Eduardo. Si nos haces hacer el gran favor de activar como host. Ahí está. Muchas gracias.
Okay, de nada. Bueno, hello everyone. Thank you for the introduction. As our host was saying, I am a real estate attorney. We have a law firm called Trust Rivera Law that operates mainly in Riviera Maya, but we do handle deals in other regions of the country, specifically tourist destinations where foreign nationals are buying property in Mexico. We not only do foreign national transactions, we also do Mexican transactions with Mexican citizens, but I would say 99% of our clientele consists of foreign nationals. So that being said, the presentation will be focused mainly on the due diligence procedure that we need to conduct to purchase real estate in Mexico. And it's focused, of course, towards brokers, right? So to start with, and I don't know if it's possible to put in the presentation so we can sort of go item by item.
¿Ya la pueden ver la presentación?
Yeah, perfect. Sí, gracias. Okay, so basically, as I was saying, this talk will be focused mainly on the due diligence procedure needed to make sure that a transaction is safe and legal. Oftentimes we'll encounter that, and especially in Riviera Maya, that title may not be clean, or maybe the seller is not who they claim to be, or many other factors that in the end can affect the validity of a real estate transaction or the conveyance of title. So getting into the subject matter, I think that first of all, we need to identify who are the parties that are involved in a real estate transaction. So we have, on the one hand, the seller, on the other hand, the buyer, on the third, the notary, the attorney, and this may or may not be involved an escrow company, right? So the seller, of course, is a person who owns the property, whether it's land or a finished product. The buyer is a person who's interested in buying the property. And then the notary is an integral part of the deal. Basically, without a notary, a real estate transaction will not have validity, official validity before third parties. So every single real estate transaction in Mexico has to go through a public notary, and basically the public notary will issue the purchase deed and record it before the public records. The role of the attorney in this, and some transactions may or may not involve an attorney, is facilitating the transaction, whether it's for the buyer or the seller. I think it's, in this case, it's important to note that the notary will not act as the attorney of any of the parties involved. Okay, so the notary does not represent either the buyer or the seller, even though part of the job of the notary is performing a sort of due diligence on the property. That being said, though, they will, if they don't obtain something or something is amiss, they will not act on behalf of any of the parties to obtain that document or to solve the issue. And that's where the attorney comes in, right? So many times we've had deals in which maybe they were missing a certificate, maybe there was a lien on the property, maybe there was litigation, or maybe just the parties did not have their complete file. So we stepped in and we helped the parties either solve the issue or obtain the necessary documents, and we were then able to facilitate the transaction and actually make it happen. Escrow company, as I'm sure all of you know, some of the transactions involved in an escrow company, some of them don't. In the US and Canada, of course, escrow is very common. It's used pretty much in every single transaction, not so much in Mexico. However, in some cases, we do recommend the use of an escrow company, especially when we're talking about either large amounts of money, maybe pre-sales, or it depends on each particular deal. So the escrow company may or may not be involved in this. And luckily, we do have escrow services available in Mexico and Riviera Maya. So those are basically the parties that are involved in a real estate transaction. Now, the next one, and this is important because of the area in which we conduct our business. In Mexico, there's this geographical zone, which is called the restricted zone. What is a restricted zone? This is basically a strip of land that goes 50 kilometers from the border, from the coastline, I'm sorry, and 100 kilometers from the border, in which foreign nationals are prevented from owning fee simple interest. What does this mean? In Spanish, this will be called the dominio pleno of a property. So basically, they're not able to purchase land under their own name, right? If we go further inland, let's say, for example, San Miguel de Allende, this is not an issue. They can just purchase it through a normal escritura pública, through a purchase deed, right? So that limitation in ownership by foreign nationals means that there are two ways in which they can actually purchase property. And by they, I mean, of course, a foreign national, notwithstanding the nationality. So the first vehicle, and the one that is probably the most common, is a bank trust, what is known as a fideicomiso. So basically, a bank trust means that the buyer will buy the land, and it will then grant it into a fideicomiso, and the fideicomiso bank trust will be managed by a trustee bank, right? The trustee bank will act upon the instructions of the emisario, which in this case is a buyer, and you know, they can rent, gift, or whatever they want to do. Difference being that title will be under the, not under the individual property. It's a very safe vehicle for many, many years. And I would say residential transactions, as a rule, involve a fideicomiso. One of the main advantages of the fideicomiso is that you will name a main beneficiary, which is usually the buyer, and then the main beneficiary can substitute beneficiaries. Substitute beneficiaries can be spouses, family members, friends, partners, whoever they want. And then in case of the demise of the main beneficiary, or even upon the instructions of the main beneficiary, the rights of the bank trust will be then transferred towards the substitute beneficiary. So in the case of estates, wills, testamentos, this offers a great advantage because basically you eliminate the need to go through the probate procedure. Probate procedures are basically what is called in Mexico an adjudicación de herencia. And this means that once a person passes, all of their assets will be put on hold, will be frozen for a certain amount of time until attorneys and the executor of the will are confirmed that there are no outstanding debts on the estate. So some of them can go easy. In other cases, they can literally take years. So end of the day, a bank trust is really a very safe and practical way of owning property in Mexico. There than the bank trust, and there is a certain cost involved in the bank trust as well. Basically, we need first to obtain a permit from the Ministry of Foreign Affairs, the Secretaría de Relaciones Exteriores. So that's step number one. That costs around 20,000 pesos. And you know, that's it. That's the duties that are defined by the government, right? So once we get that, we will then need to actually incorporate the bank trust. So first we have the permit, and then we incorporate the actual bank trust. Now, something very important that we need to keep in mind on this one is that if we're talking about a condo or a building or a subdivision, we need to have the condominium regime registered and ready before we can actually do the bank trust. So for pre-sales, this is something that we need to keep in mind. So that's one way of owning property in Mexico by foreign nationals. And then the other one is a Mexican corporation. Could be an LLC, for example. So Mexican corporations are usually used for commercial purposes, meaning if a party is buying, call it a business, a hotel, a restaurant, or maybe a portfolio of properties, then a Mexican corporation would make more sense than a bank trust. Why? Basically because of the tax write-offs, right? If you're operating a business that has, you know, income, losses, profits, so on and so forth, you can deduct some of your operating expenses for the Mexican corporation. If not, for residential properties, it is a little bit more complicated because basically with a corporation, you need to comply with all the rules that are set forth by the government, and you need to file monthly reports, even if the corporation is not reporting any income, you still need to file monthly reports. So basically, with a Mexican corporation, you will also need to have an accountant involved, and this involves another cost, and it sort of brings another player into the game. But once again, if you're looking at a commercial deal, the Mexican corporation is the way to go. So that being said, we have those two vehicles for a foreign national being able to own property in Mexico. We either do the bank trust, which we can say it's for a residential property, or we do the Mexican corporation, which is for a commercial property. Now, keep in mind, a client may choose to go with a Mexican corporation for a residential deal and the other way around. There's no restrictions on that, but it's just more of a matter of practicality. Okay, can we go to the next slide, please? Okay, so with the Mexican corporation, we already discussed how we incorporate the bank trust, which is obtaining the permit, filing it before the bank, incorporating the trust, and paying the fee. With a corporation, it's a bit of a different process. The first step with a Mexican corporation is that you need to pick 5 names, okay? And basically, the more uncommon the names, the better, because these names will be submitted before the Ministry of Foreign Affairs, and that entity will then conduct a search to make sure that there are no other corporations that share the same name, right? So, of course, if you go with a common name, chances are that it's already taken. So the recommendation on this one is try to go with the most weird or uncommon name you can think of, and you're more likely to get it approved at the first go. But basically, you need to choose 5 names, which will then be submitted before the Ministry of Foreign Affairs. Once that is submitted, we need to provide information to the notary, and keep in mind, the Mexican corporation needs to be incorporated before the notary public. And we will then submit information on the actual structure, the corporate structure of the corporation. So this means who are the partners, what's share split, and who has power of attorney over what. Basically, that's it, right? They will request other items, of course. We will need the RFC's number. We will need the names, IDs, proof of address, so on and so forth. The cost of the corporation varies from notary to notary, but you can call it around 25,000 pesos on an average. The time for incorporating the company, a corporation, is probably shorter than a bank trust. A bank trust can take, call it around a month, maybe a little bit more, and a corporation is usually done within 2 to 3 weeks. So, end of the day, both vehicles have advantages and disadvantages, and I think that the most important part on this one is we need to define what is the purpose of the transaction. As mentioned, if we're looking at a client that is buying maybe a 2-bedroom condo just for vacation purposes, go with a bank trust. If we're looking at a client that's buying maybe a building, which will be rented out, go with a corporation, right? So that being said, I would like to make this a little bit interactive. So if anybody has any questions or comments as we progress through the presentation, please feel free to cut in and make any questions that you may have.
Eduardo, I have a question.
Sure.
I'm having this process with a customer. So sometimes it's difficult to know what kind of company talking about, if it has to be an SADCB or maybe a responsabilidad limitada, for playing with the tax strategy. because I have this customer who wants to develop. So all this procedure that you are talking about, I was living it, but then I feel a little bit stuck because I don't know how to perform the best way for my customer to ensure that we are doing the right thing. No? So do you provide also all these advice for our customers?
Yes, of course we do, and basically this is something that we do on our own, but we do have a team of specialists behind us. So really, depending on the specific nature of each venture, it's how we determine the type of corporation that we need, right? The most usual is, of course, the SADCB, the Sociedad Anónima de Capital Variable, and in some cases, the SDRLDCB, which would be basically an LLC, a limited liability, right? And now, that being said, and I'm glad you touched on this subject, a lot of developers, what they'll do is they will incorporate a bank trust, a fideicomiso, and grant the land into the fideicomiso, right? So this makes it a little bit safer, but we need to be wary about this because basically once it's put into a fideicomiso, then if a lawsuit or litigation should come up, hopefully not, but if it does, then the property will not be able to be legally seized. It becomes inembargable, right? So we do need to take a look at that. And for determining the type of corporation, I would say we need to study first what are the needs of the client, and then based on that, we can advise on whether it's an SAPI, SRSB, SDRLSB, or similar.
Thank you. Because also my customer, for example, has a LLC company in the States. And it was very weird because first he bought the land because it was a good opportunity in Tulum, Mexico, as a tourist, no, as a being as a tourist, and now he is doing maybe the opposite, the opposite, no, it's doing all the procedure to be residente in Mexico, and well, this kind of links is very important to know because sometimes the way that they send the money to the company in Mexico, and I'm very glad that you are the one who can help us in this kind of matter.
Yes, we'll be more than glad to advise on that. That is basically corporate law, but end of the day, corporate law and real estate sort of go hand in hand, right? They are related, and one links into the other. And another thing to note on the Mexican corporation, which I think is important, is that now you do not need to have a Mexican partner. Some years ago, if you wanted to incorporate a company in Mexico, you had to have a Mexican partner, even if it was a 1%, right? Right now, you can have a fully foreign-owned company as long as you have a Mexican legal representative. Keep in mind, legal representative, not partner. So end of the day, this makes it a little bit easier for foreign nationals to actually incorporate a company, and it may give them an added degree of confidence.
I have a question. Hi. And in the case of the bank trust, if the buyer becomes after having the bank trust and if he becomes Mexican, if he has the naturalization process done, what happens with the bank trust? It has to be ending. It has some cost for the person who has the title.
Yeah, well, not necessarily, right? End of the day, a Mexican national, as I mentioned a little while ago, we call it a developer, could incorporate a bank trust, and the land could be owned by that bank trust, even if you're Mexican. Now, in the case of someone who obtains temporary, permanent, and then Mexican citizenship, they don't need to put the property off the bank trust. They can, but basically if they do, then we're talking about another transfer of title, and that will entail the cost of transfer of title. So, transfer of title means the closing. So that's around 7 to 9, 10% of the value of the appraisal of the property price. So we don't really recommend that, right? End of the day, it doesn't give you any added advantages, but it will cost you a lot more money.
Thank you.
Okay. All right. Any other questions on bank trust corporations? Okay, so moving on. We've defined the parties, right? We've defined the vehicles for ownership. And now we're going to go into the actual purchase procedure. Once again, the purchase procedure is a bit different than in other parts of the world. In a normal transaction, we start off with an offer letter, right? So the offer letter, most of the time, is drafted by the broker, and it will outline the parties involved, which we already covered, the property with a full legal address, the price, right? In some cases it may be lower because the buyer is throwing an offer that is not what the initial price was set at, and sort of the terms of payment. So the offer letter will be signed by both parties. And now keep in mind, even though it's signed by both parties, the offer letter is not a legally binding document, right? End of the day, an offer letter would be similar to what is called a letter of intent on LOI, right? So it's basically just saying that Mr. X wants to buy this property from Mr. Y, okay? So we have the offer letter. Once the offer letter is accepted and executed by both parties, we move into what's called a promissory agreement. Now, promissory agreements are usually done for pre-sales, but they're also done for resales. What the promissory agreement does is, number one, it creates a legal bond or a link. It creates an obligation between the two parties, meaning the promissory seller and the promissory buyer. Okay, so usually this involves a down payment. The percentage of the down payment can vary greatly. It can go from 10%, and I've seen some of them go 90%. It really depends on each deal, right? Maybe it's a pre-sale, and if you put down more money, you'll get a huge discount. Or maybe people are a little bit more cautious and they want to put down as little money as possible. So that really will depend a lot on each deal. Now, something important on the promissory agreement. This is where the actual title conveyance procedure starts, right? Once we get to the promissory agreement, we can say that we're actually looking at a real estate transaction. So it will outline the price, it will outline the payment schedule, it will outline penalty fees, both for buyer and seller, and super important, it will outline the delivery date and ideally the date of execution of the purchase deed. I say ideally because you know better than I do, a lot of pre-sales, they don't have the condo regime ready yet. So if this really doesn't depend on the seller or the developer. There are many authorities involved in granting a condo regime. A condo regime is basically a thick binder with a ton of documents that need to be obtained from different governmental instances. And the government is really not the most efficient machine in the world, so this can take a long time, right? So something I always try to advise my clients is we need to have a date for delivery, of course, and we need to have a date for execution of the purchase deed. And what the way we usually do it is we talk to the developer and say, you name the date, right? We're not going to impose a date on you if you don't think it's doable, but buy yourself enough time in which you know that you will have the condo regime ready. Why is this? A lot of times the buyer will be granted possession of the property, right? And once they have the keys in their mind, it's easy to think, hey, the property's mine. It's not. It's actually not. it belongs to the developer. And in that gap of time, anything could happen. Basically, the developer could get sued. There could be a lien recorded against the property. I'm sure you've all heard some horror stories about people, watching TV in the middle of the night and their doors being kicked in by the police and getting thrown out. So it is very important to differentiate in the promissory agreement the fact that possession and ownership are two completely separate topics, right? So once again, I do recommend that when we're looking at a promissory agreement, we try and establish a date not only for the delivery, but also for the execution of the purchase deed. And believe me, you will get a lot of pushback from many developers because they don't want to be bound by a specific date. But once again, we consider that as a risk factor. We've seen some cases in which title takes 2-3 years to get transferred, just because the developer has been paid and they don't have any urgent need to actually go through the whole crucible of getting a condo regime recorded, right? Okay, so that's a promissory agreement. Then once we have the promissory agreement, we then know when we expect to close on the property. By close on the property, we mean transfer the title on the property from the seller to the buyer, right? So we go into the obtainment of documents. Sorry. So and this is where it gets tricky, right? And I would say this is where we as attorneys probably spend the most time on a deal. The documents requested by the notary are extensive. They're quite a checklist, and in the best case, they will be provided by the seller. So we have some sellers that are super organized, and you ask for it, and they have this beautiful zip file, and everything's updated, and then we're all happy. We have other sellers though that are maybe not as efficient, and they pretty much don't have anything at all. So we step in and we assist in the obtaining of documents. Which documents? Certificates of no liens, certificates of no debt, such as water rights, property taxes, and others, right? I'm really summarizing this, but once again, the checklist on the documents is extensive. And this is where most transactions sort of hit a snag, especially if you're talking about a first-time buyer who's maybe from the US, Canada, whatever, and you tell them, well, we need a constancia de una deuda de obra pública, and you're basically they don't understand what that is. I mean, even some Mexicans don't understand what that is, right? So again, we as attorneys are able to obtain those documents, and we are lucky enough to have contacts that will actually expedite this. A constancia, a certificate of no debt, depending on the entity, but it can take call it maybe a month. And if we're looking at a deadline with a penalty fee, a month is a long time, right? So sometimes because the parties were not able to obtain a document in a timely fashion, they get hit with a huge penalty fee, right? So again, this whole obtainment of documents is important. And part of those documents will be the condo regime. Without the condo regime, it is impossible to transfer title on the property. Basically, what the condo regime does is it subdivides a project. Let's say you have a piece of land and you build a building on it, and the building has 20 apartments, right? If you don't do a condo regime, that whole thing will be recorded under one single record number in public records. So that means if someone were to buy it, they would need to buy, they would be buying the land and the building. So with the condo regime, what it does is that it subdivides the project into individual units, and each individual unit will be assigned a record number and a cadastral number, el catastro, which is basically the property tax number, the predial, right? So once again, without the condo regime, they're just impossible for us to transfer title. So once we've done all that, we get to the actual transfer of title or the closing. As mentioned, this needs to be done through a notary public. There are many, and the buyer usually is the one that chooses a notary public. Why? Because the buyer is the one that will be paying for this. As mentioned earlier, the cost of this varies, but it goes from 7 to 8, 9, up to 10%, right? So we have the offer letter, we have the promissory agreement, we have obtained the documents, we have the condo regime, and now we go into, and we have, of course, a vehicle incorporated, right? Either the bank trust or the corporation. And now we need to actually coordinate between the parties a time and date in which they will be able to meet at the notary. Well, usually it's done at the notary's office. Some notaries will send someone, one of their attorneys, to sign off on the deed. We recommend that all parties are present at the time of closing, because basically what they'll do is they'll go through the purchase deed. It's not really fun because some purchase deeds are super long, but the notary will read through it and will explain to the parties the legal implications of all the terms and conditions established in the purchase deed. That being said, before we reach that point, what we do, our firm, is we review with the notary the purchase deed in detail. And you would be amazed at the number of mistakes that you can actually find in a purchase deed. And we need to be careful with this one, because let's say if they put in the wrong unit number, is 5 instead of 6, and then they do 6 again, then basically the seller is incurring in fraud, right? So we need to review the purchase deed in detail. And once we're all satisfied with that, we will then proceed to signing off on the purchase deed, and the deed will then get sent to the public records. And then we enter into a void, because it's really hard to know when the deed will be actually recorded. We've had some cases in which the deed is recorded in a month, and we're currently looking at a case in which the deed has not been recorded for over a year, right? And why? It sort of depends on the workload of the public records, who gets assigned to it, and sometimes, to tell you the truth, they even misplace it, right? So it is important to note that the transaction will not be perfected, quote unquote, until we have the actual recorded purchase deed. You will walk out of the notary's office with what is called a certified copy, which is basically a copy of the deed signed and stamped by the notary. And even though that's a valid document, it is not yet, once again, perfected, because it is not recorded. So we need to follow up with the notary and know when the actual recorded deed will be issued. So I don't know, any questions on that part? Okay, can we move to the next slide, please? Okay, so going into the actual subject matter, and sorry if the intro was a little bit long, but I think it's important that we all sort of know exactly what we're looking at, and sort of the components of a real estate transaction. So due diligence. You as brokers, I understand, are not attorneys, so this is a little bit detailed. But basically, what you guys need to look at as brokers is, number one, the deed through which the owner holds ownership of the land, right? So this can be tricky. Some projects will go into joint ventures, right? Through which one party sort of puts up the land, and then the other party will develop it. And then in the promissory agreement, it may or may not state that the entity, company, or individual that is developing the land is selling the land. Watch out for this one. It's illegal, right? I mean, end of the day, they're not able to sell the land because the land, it's not theirs. So the number one thing we need to take a look at is the initial purchase deed through which the seller actually holds title and holds rights of legal ownership over the land, and is therefore able to transfer those rights of legal ownership, right? So, sorry, that would be the starting point. Knowing that the seller is actually the owner of the land, and this is evidenced through the initial purchase deed. It may be a different type of document, right? If it's an ejido property, we're looking at a completely different animal, but not every title to the land will be an escritura pública, right? There can be other documents. It's a little bit technical. I don't even go into that. But once again, we need to make 100% sure that whoever is claiming to be the owner is actually the owner of the land. All right. So that's number one. And then then the other thing that we need to take a look at usually is the construction license, right? Why? Because if they don't have a construction license and they're doing pre-sales on raw land, you don't know if it's actually authorized or not, right? I mean, they may be selling, we're going to do a 200 unit project here. And if you look at the construction license, it says, no, you're going to do 2 units, right? So it is important to request a construction license. And if the developer is not willing to share the construction license, there may be something fishy with that, right? So we do recommend that you request a construction license as well. The other thing that we recommend obtaining is or requesting at least, is a certificate of no liens, right? So this is basically what is called a certificado de libertad de gravámenes. And as the name implies, it's a certificate issued by the public records, which states whether or not there are any liens placed on the property. That being said, these documents have a 30-day validity. And, just because the developer shows you one, it doesn't mean that they can turn around literally that very same day and place a lien on the property. But at least it gives you a degree of certainty knowing that there are no liens on the property. And now, that being said, if there's a lien on the property, it's not really a red flag, right? The great majority of developers will obtain credits, financing to finish a project. Créditos puente, different types of financing. So once again, it's not really a red flag, but it does help us knowing where we stand in regards to the project. Because if we see that, maybe there's pending litigation, red flag, stay away from it like the plague. So certificate of no liens. The other one, and this is sort of tied into the construction license, is the zoning, right? What do I mean by zoning? For example, Tulum, right? Some properties, a lot of them actually, have been built on what is basically a natural reserve, right? So this is this was not enforced in the past, but recently it has been taken a little bit more seriously by the government, right? So we need to know that the zoning is actually in accordance with what is allowed with the project, right? And this takes even greater relevance when we're looking at a commercial deal, right? So if your client wants to set up maybe a condo hotel, maybe a restaurant, maybe whatever, we need to make sure that the zoning is in accordance to what they plan on doing, okay? Then after that, we go into, and this is more for commercial properties, of course. If your client is buying once again, a hotel, we need to take a look at the operation license, meaning that, the government is actually authorizing that particular company to operate that particular business. Then we go into the certificates that I was mentioning earlier, right? We need to take a look at the certificate of no debt of real property tax, the predial, the no debt of public projects, which is obras públicas, water rights, electrical services, and in the case of resales, HOA fees, right? Now, another thing to keep in mind, and this is sort of backtracking into my first item, is the chain of title, right? Usually, in Mexico, if you own a property for 10 years, you are considered the owner of the property. Now, it's not like, I just squat on a property for 10 years and it's mine. No, you need to meet certain criteria to do it. But if we know that title goes back at least 10 years, then that adds another layer of confidence to the fact that title is actually clean and that the property would be able to be legally transferred. Okay, so any questions on that one? Okay, so moving on to the next slide, please. Perdón, podríamos pasar a la siguiente. Okay, now, and end of the day, what I'm mentioning here is definitely not something that you as brokers need to look at. As mentioned, you as brokers, what you need to focus on is the escritura pública, the purchase deed, the construction license, and so on, probably, right? If you have those three, then once again, you know that at least title will be able to get transferred and the project will be able to get built. In our case, as attorneys, and we're talking about let's call it a little bit more extensive due diligence procedure, we will request other documents, such as, for example, the letter from the tax authority stating the good standing on the company and that they don't own any back taxes, right? Why is this important? Because end of the day, the property could, because, and if it gets seized, then, the government will go in first and everybody else will come in second, right? If we're talking about a corporation that's selling, we need to take a look at the articles of incorporation, the acta constitutiva, right? Once again, that we will know that the company's corporate standing, we will know that it's actually existent, we will know that it's recorded, we will know who the shareholders and partners are. And within this one, usually it's also included the power of attorney, right? So if we're talking about a purchase through which the seller is a corporation, they will assign a power of attorney, right? So whoever has a power of attorney will be the one actually signing off on the deed. Now, something to keep in mind, super important. There are different powers of attorney. Not all powers of attorney are equal, right? So the one we need to have in order for the legal representative of company to sign off on a transfer of title is what is called actos de dominio, right? So acts of domain, I guess, would be the adequate translation on that one. If they have other types of power of attorney, that's okay. We do need the acts of domain in order for the legal representative to be able to transfer title on the property. With this, of course, we also need the IDs of the legal representative and shareholders, just to know that they're actual existent people and, not made up, because again, you'd be amazed at what we see, right? Construction license, we already covered that. And then as we were saying, and this ties a little bit into the zoning issue, environmental authorization, if applicable. When does this take relevance? For example, if they're buying beachfront, right, and part of the property involves beach, which is actually a concession. You cannot buy beach in Mexico. It's a concession granted by the government. Then you need to take a look at that, right? Because there are different types of concessions. Some of them are just for use and enjoyment. Other ones, you can actually set up a business, a beach club, whatever, right? But this will impact greatly the value of the property or the actual use of the property. In some cases, they just buy the beach and you can't build anything on it. You put in a palapa and you'll get hit with a hefty fine, right? So environmental authorizations, depending on the deal, if we're looking at a condo, resale, pre-sale, we don't need it. If we're looking at other types of deals, or in other places, call it maybe Holbox, call it maybe, I don't know, Bacalar, stuff like that, then we do need to take a look at the environmental authorization, because it could shut down a project pretty easily, right? As we said, then the liens, attachments, mortgages, whatever, this is usually defined through the certificate of no liens, the certificado de libertad de gravámenes, right? If we're looking at a resale, we need to know if there are currently any rentals on the property. Now, keep in mind, some people will be happy to buy a property that's already rented because they're doing it for the investment, right? In other cases, though, buying a property and then finding out that there was a pre-existing rental agreement can be a nightmare, right? I mean, you're basically looking at a long, tedious litigation process to get someone evicted. So that's important as well. And lastly, and this is sort of stepping it up, for high-end deals. We are able and can review if there's any pending litigation on the property, right? And this involves both civil and criminal instances. So we'll do an inside search, right? And if there's anything pending on the property, it'll pop up and we'll let the buyer know. Okay, nos podemos ir a la siguiente, por favor. Okay, then as we already covered this, but basically through the zoning certificate, through the environmental authorization, through the construction license, and through other items that we've already mentioned, we are then able to determine what type of use you can give to the property. Again, if it's residential, if it's just a condo, we don't really need to worry about this one. But then again, if we're talking about raw land, commercial, whatever, then we do need to take a look at this one a little bit better, right? We need to know, of course, the metes and bounds of the property. So, dimensions, locations, so on and so forth, if there are any improvements on the property or not. Now, keep in mind that, at least in Mexico, if you build, let's say you build a house on your neighbor's lot, you just gifted someone a house, right? So we do need to know with certainty what's exactly the surface area that we're looking at, what is usually called the polígono, right? And then, if there, and lastly, if there is any items that could affect the real property and that may change the actual surface area, right? Maybe an easement, maybe a right of way, or others, right? So that's something that we also need to take a look at. So I guess summarizing, that's what we're looking at a due diligence procedure, right? What I mentioned is really based on what we would do as a due diligence procedure if a client engages us to do it, maybe for a commercial transaction, right? Maybe a high-end deal. For you as brokers, I think I've mentioned this several times already. Take a look at the purchase deed, at the initial purchase deed. Take a look at the ID or articles of incorporation of the seller and the construction license. So if you cover those three, at least you know that, once again, no red flags, and you're probably able to move on with the deal. Okay. So going back into the promissory agreement, right? A promissory agreement, of course, end of the day, it could be written by hand on a piece of paper in a restaurant. It could, as long as it includes certain elements that give it validity and create an actual legal bond between the parties. So we need the header or title. So that's sort of on the very top. It needs to say promissory purchase agreement, or incorporation of trust agreement, or so on and so forth. It needs to define the parties, which we already covered, seller and buyer. We need to define the property that is being purchased. So it's going to be lot 1, block 7, sub block 2, so on and so forth. We need to define the price, saying how much property is going to be worth, the form of payment, the date of payment, and then we covered these two already: the date of delivery of the property and the date of transfer of title. And this one is important: the penalty fees. A lot of pre-sale agreements, especially the ones that are actually drawn up by the developer, will not include penalty fees, right? So basically what this means is that if the developer is overdue, call it a year in delivery, was too bad. You don't have any recourse. Well, I mean, you do have recourses, but not economic recourses, right? It's not like, hey, you're gonna owe me $500. I'm sorry?
I have a quick question. This is Nicole. My question is, right now that I've noticed with different developments, some of them are accepting DocuSign. How legal is that? And others are making us like send it in FedEx to the client, 3 copies, have them send it back. If you said it could be like written even on a napkin, like what is the legal behind having either the physical and or the DocuSign?
Okay, yeah, good question. Actually, DocuSign is accepted as a valid method, right? And it makes everyone's life a lot easier. But basically, something I always recommend, and this is just good corporate practice. Try and have a hard copy of the agreement, right? If litigation ensues, God forbid, yes, DocuSign will be taken as valid, but then we need to bring in a court-appointed expert in IT that will say, yep, indeed, this was signed by the parties on this date, and that involves an additional cost and an additional time. So to answer your question, yes, DocuSign is a valid form of executing an agreement, but in my mind, if we are able to obtain a hard copy signed by the seller at least and have it on file in your offices, that just is additional peace of mind.
Thank you.
Welcome. Okay. Then penalty fee. Notices, in case that any notice needs to be served, where should it be served? So we need to include the addresses of the parties, and these are usually included in the offer letter. But again, that is part of the agreement, right? And lastly, the place in which the agreement is actually executed and which jurisdiction it would be bound to in case of litigation, right? So we could execute an agreement in Mexico City, but then we would submit to the jurisdiction of Quintana Roo and the other way around, right? So basically, these are the elements that we need to take a look at in order for an agreement to be actually valid and legally binding. Okay, so basically, yeah, it could be written on a napkin as long as it contains all these elements that I just mentioned. Okay, nos podemos ir a la siguiente, por favor. Okay, and I'm sorry, let me just move this a bit. Oh, there they are. Okay, so what are the elements necessary for actually conveying title, right? We need the incorporation of the purchase vehicle, which we already covered. So it's basically the bank trust or the Mexican corporation. Then we need the numerous documents required by the notary, which again are many. I would be glad to share them with you via email, but really if we go into that right now, we could take another hour, right? And then basically from the seller, we will need the articles of incorporation, the proof of good tax standing, the constancia de situación fiscal, the POA, the power of attorney for the legal representative, the ID, and if we're doing it through a bank trust, the bank will require a KYC format, which is basically a know your client format, right? And this is mainly done for anti-money laundering issues. Okay, and last here, proof of address. Then from the buyer, we will need their official IDs. Now something important, a driver's license is not a valid proof, is not a valid ID in Mexico, right? It is in the States, so we get that a lot, right? Some clients will be like, okay, just I brought in my official ID. It's a driver's license, and that will not be accepted as valid ID. So it's really the way to go on this one. Then we need sort of the proof of payment to the seller, right? Maybe the bank statements, maybe just the wire transfer receipts, whatever. But the notary will require to have evidence that the buyer has actually paid in full to the seller the price that was agreed on initially on the offer letter and the promissory agreement and on the purchase deed. Then we need the know your client formats. This is again required by the bank, and the payment of the bank trust fees. Okay, so basically, we, as mentioned at the start of this conversation, we need to obtain the permit from the Ministry of Foreign Affairs, number one, and then after that, the bank will charge the client a fee for incorporating the bank trust, number one, and a fee for managing the bank trust, and this is annual, right? And then on the property, we will need, and really summarizing this one, the condo regime, a certificate of no liens, the certificates of no debt, the receipt of payment of all the certificates, and the cédula catastral, which is basically the property tax ID number. Right? La siguiente, por favor. Okay, so basically, what are the items that we need to review before entering into a purchase agreement? We sort of already covered it, but you know, just ABCing it: the initial purchase deed, the articles of incorporation, the zoning, the construction license, the certificate of no liens, and lastly, the condo regime. If we go into a project that already has a condo regime, believe me, everyone's life will be a lot easier, right? And then the forms of purchase, as we said, we have a pre-sale, we have a resale, and then we have the finished product, right? Which is basically the initial purchase, but the unit or the property is already done, right? It's not being built, it's ready to be delivered. Y podemos hacer la siguiente, por favor. Okay, and basically with this, I believe we've already covered this, but end of the day, due diligence, which will be also referred to as a title abstract, right? I mean, if a client of yours says, I would need a title abstract, end of the day, what they're asking for is a title search, i.e. due diligence on the property, right? So the title search basically means what we just covered extensively so far. I'm not going to go into it again, but once again, just making sure that, you know, the property can be duly transferred and it doesn't have any liens, and you know it's owned correctly, right? And then the due diligence in property purchase is something you can do as brokers initially, but end of the day, we do highly recommend that if you think there's something fishy maybe, or let's say you are exclusive to a certain development, or if you're making a lot of deals with one development, we take a look at the sort of title abstract, you know, the legal background of that specific development, and you know that way you know that you're selling to your clients something that will not cause them headaches down the line. La siguiente, por favor, o ya es la última. Okay, and then, you know, basically what we just mentioned again. So it's checking the use, checking the zoning, reviewing the promissory, and I cannot stress enough the importance of the promissory agreement, right? we really need to take a look at the promissory agreement. You know, sometimes we have clients that come in with a promissory agreement already signed, and you know, they're not getting what they paid for, or they get delayed or whatever, and that puts us in a tight spot as an attorney, because you know, you already signed off on this, right? So redoing it, you know, through an addendum, a modification is very hard, right? I mean, oftentimes the seller will be like, you know, you signed with what you signed. I'm sorry, but that's the way we're gonna handle this, right? And then, you know, lastly, we need to check about the easements, rights of way, encumbrances, so on and so forth. So basically, that I think that sort of covers the due diligence part of the real estate transaction, right? Hay otro slide, o me parece que ese ya es el último. Okay. And okay, what is it that we do, right? We covered sort of the broad strokes of the due diligence, right? We cover what you can do as brokers. We've covered the parties. We've covered several items, right? What is it we do? End of the day, what we do is we facilitate all of this red tape, back office, filings, and basically all the boring stuff that you need to do to actually close on a transaction, right? So what we like to tell our clients is that, you know, don't think of us as a law firm. Think of us more as your post-sale department, right? You as brokers, because you need to be focused on selling, not on getting documents, or, you know, chasing notaries or chasing filings or whatever. So what we do is basically take that on for you and make it a lot easier, not only for you, but for your clients. And end of the day, having a third-party attorney, and this is important to note, we are an independent provider, right? So basically, having a third-party attorney will increase the confidence of the buyer, and it's actually a sales tool, right? I understand that maybe a lot of people say, ooh, we got an attorney involved, then there must be something wrong with this. We are not that type of law firm, right? Once again, our main practice is real estate. And what we do is we try to make the deal happen. We don't try to make the deal not happen. It's the other way around, right? We are actually here to help you close, and at the same time, make sure that your clients are not getting a bad deal, or are going into a legally risky situation. We've had some instances in which we definitely recommend that the client does not go through with the deal. We've had some instances which were just clearly a fraud, right? So you know, you sort of see it all in this line of work. But again, end of the day, what we're here to do is help you close on the property, and you know, you don't have to go into this whole lengthy explanation that we just went through with each client, and you know, having them 2-3 hours on the phone, right? And you know, we each have our sort of areas of specialization. So you know, I don't sell property is so you guys shouldn't be giving legal advice either, right? Okay, Lassie. Okay, so that concludes my presentation. I know it's not the most interesting subject in the world. It can get technical a little bit, but end of the day, I hope that you know, I at least gave you guys some sort of semblance of what we're looking at when we need to conduct a due diligence. Some sort of semblance of what you guys need to look at or request from the seller, and what it is that, you know, entails the whole closure process, transfer title.
Eduardo, una
I know, go
pregunta.
ahead.
Sí.
Francisco Pavón por acá. Oye,
Toma.
en el bank trust, when the substitute beneficiary, does it have to go through the notary at the time of taking possession by the substitute beneficiary, or is it an internal thing with the bank?
No, it's actually an internal thing with the bank, right? The substitute beneficiary will be appointed usually at the incorporation stage of the bank trust. That being said, once a bank trust is incorporated, substitute beneficiaries can be removed or included. So it basically will be an internal process that is done by the bank, right? End of the day, the bank trust owns the property, and whatever beneficiary it is contemplated in the bank trust is done internally by the bank, not the notary.
So if the beneficiary passes away and the beneficiary takes possession, there's no insabi, there's no nothing, and he's
No. There's none, because end of the day, there's no transfer of title, right? I mean, the bank trust is the one that holds the title. So the ISABI, which is the purchase tax, is not applicable because there's no traslado de dominio. Know what I mean? So under the record, it's exactly the same bank trust, and whatever beneficiary the bank trust has is we're not the land or the property is not actually changing owners.
Okay, thank you.
Welcome.
Eduardo, thank you so much for your time this morning. I'm Keith Smith with Runaway Realty in Puerto Morelos. Is your office local to Playa del Carmen?
Yes, yes, it is. I'm actually based out of Puerto Aventuras, and we have an office in Playa Car. So yeah, we are a local firm.
Okay, and would you be willing to share, and if not, maybe you could, we could talk privately, but I'd be curious to know what your standard rate is for a residential transaction with the Fideicomiso, and also what escrow companies you work with.
Yes, of course. On the rates, yes, I would rather discuss it on one by one. They vary, right? I mean, some deals are a lot more complicated than others, of course, right? And but yes, I'll be. I guess the organizers can share my information with anybody that's interested, and I'll be more than glad to discuss on a one-on-one our rates, services, and more specifics.
Okay, thank you.
Hey, everybody, this is Nicole with Net Real Estate. And I just want to tell you guys, I'm going to admit it, he's my secret weapon when closing a deal. After having so many issues with other firms due to them just, you send them a contract to check and they were wanting to do like $50,000, 50,000 changes that was making the clients very nervous and they weren't necessary. Now that I've been working with Eduardo, we've closed over 50 transactions. And he is literally my secret force that I'm using at Net Real Estate. So I highly recommend. I can tell you after 50 transactions, we've been through a lot of successes. We've also saved clients from fraud, thanks to the due diligence, from making sure that these developers, they either didn't have paperwork or they didn't even own the land and they were selling units. So thanks to Eduardo, he saved me a lot of face in front of my clients. And I wanted to tell you guys, I personally recommend him.
Thank you, Nicole. Yeah, we've had an interesting run, that's for sure.
That is so interesting. Thank you very much, Eduardo, because all these tools that you have given to us and all the knowledge that you have, all the experience, I'm very sure that this is going to be very helpful for us. And we will be providing more professional service to all our customers, just as Nicole says. It is a great tool for us to having firms like yours. And we appreciate very much that you take this time. It was a very good presentation. Thank you very much. I don't know if somebody has another question. I'm sure that this presentation is going to be sent from the office, from NAMPI, to all the participants. So I don't know if somebody wants to say something else, and I appreciate that. Thank you so much, Eduardo.
More than welcome. And just as a parting shot, You know, my contact information will be shared by the organizers. And, you know, if you guys have any doubts or, you know, maybe you're not clear on something, feel free to give me a call. And it's not like I'm going to bill you for the call, right? So, you know, if you just need like, I'm not sure about this or that, ring me. And, you know, if I'm not on another call, I will pick up.
Thank you so much for that.
Okay.
Hey, Eduardo. Yes, my name is Theo Grishti. I work with American Realty and been doing real estate here for a while. And when I first started here, there wasn't much pre-construction, and now it's, you know, it's been going off, you know, like crazy. So I've always been trying to get documents from pre-construction developers, and you gave me a whole list of them, and I've been taking notes. But is there any that, like, there's some developers in Playa del Carmen, and they're like, oh, we're going to be finished in 2027. They still have their office is literally standing still in the spot where they're going to do the construction. And so, is there anything that, before I promote this to my client, I know, you know, there's too many intricate documents for me to look at, but is there a few documents that I could talk to the developer and like, hey, before I promote this to my client, I need to at least see these top documents?
Yeah, of course. Well, I mean, basically, once again, the initial purchase deed, right? So we make sure that the seller is actually the owner, the zoning, and the construction license. I think with those three, you know that at least the project, you know, is planned to happen, right? Because really, if they don't have a construction license, and and it's funny, a lot of times they don't even own the land, right? They have a promissory agreement on the land, and they're doing pre-sales, right? Mm-hmm. And that's basically a fraud, right? Yeah. But you'd be amazed. A lot of people do that. So they have this beautiful renders, and, you know, they wine and dine the client. And, you know, we've had some cases in which people put down over $500,000 on raw land. And, you know, that was 2 years ago. And to the day, it's still raw land. So, so yeah, we do need to be careful because, you know, there's some developers that are super professional, super honest, but then you do have the bad apple, right? So
this is the construction license, that they're the actual landowners. There was one more there I missed.
Construction license, actual landowners, and if possible, the zoning, right? And you know, basically, if we have the construction license and the initial purchase deed, and that would be, in my mind, the minimum that we need to know that they're on the up and up.
Okay. Yeah, perfect. Yeah, I know a lot of developers also, I tried it before, but to see how they're financed. I know it's very common that most developers, they use the deposits to build. And so I'm always concerned about getting the financing that they have available. Did they get a bank loan? Are they, you know, I'm not sure if that's even a documents that could be allowed to get. They typically don't want to share that information, it seems.
Well, I mean, now keep in mind that this is public record, right? Mm-hmm. I mean, you could go into the public records and request a certificate of no lien pretty much on any single property in Mexico, right? It may take you time and money, but this is not confidential, right? So if a developer says, no, I'm not willing to share that information with you because it's confidential, I'm sorry, no, it's not. It's a matter of public record. So if they don't want to share it with you, you know, there may be something fishy.
Okay, perfect. Yep, that's fine. Thank you. Appreciate your presentation.
Okay, welcome.
Okay, now you can see the contact information from Eduardo and also the Instagram page. It is in the chat.
See, and we do have a webpage as well. It's www.trustrivieralaw.com. You know, there's a bunch of information, contact information as well. So once again, if you guys need any legal advice, if you have a client interest, you know, let us know, and we're always glad to help.
There's a webpage also in the chat. Thank you very much.
Okay.
Eduardo, okay.
All right, guys.
Thank you, Eduardo.
Okay, bye-bye.
Bye-bye. See you in the next one. Bye-bye.